Mr. Connolly, what are the limits of your theory? Could someone who finished paying their loans off, right last year, sue because they were disappointed that they weren't included for reimbursement?
No, I don't think so, because there's no mechanism by which the Department of Education can write those borrowers a check. And so their injuries are not redressable. Here, there is a mechanism under which the Secretary can forgive Ms. Brown's debts, forgive Mr. Taylor's debts, and that's the difference.
What about the Chief Justice's lawn care person who doesn't go to college, starts a lawn care business, but as the Chief said, this person has some fairness concerns and feels like this shouldn't have happened and kind of level up or level down and wants to level down?
Sure. Again, the Secretary of Education has no power to give any money to that individual or do anything like that. And so even if he could come up with a concrete interest, it couldn't be redressable.
Could have persuaded him not to do it would be, I take it with the fairness concern and the hypothetical the Chief posed you. I think it would have been to say, well, this isn't fair. You're not doing this for me, so you shouldn't have done it for anyone. But you're not taking the position that that would be
No, he would not, because you have to have concrete interests, has to be particularized, can't be abstract, and so.
So it's not just the getting shut out of notice and comment.
Correct. These individuals have concrete interests. There was a $400 billion debt forgiveness program that was created, and the respondents have debts, and they're not being forgiven. And if it had gone through the proper process, negotiated rulemaking and notice and comment, we could have argued that our debt should be forgiven too.